Mentioning call kora age. Yes, yes.
Item number 5, the bail application. EMLA Act. We were supposed to file the application from 30 December. Yesterday night, I received the affidavit by officer running into 1,000 pages.
1,000 pages.
Only 1,000 pages. I didn't read.
So you're for the petitioner.
I'm for the member. I have no other alternative, my lord. I need to file a reply to make it go next.
Very good. The other side is approved. Yes. Item 5. It's mentioned out of turn. First up, next para. Learned counsel appearing for the petitioner submits that an affidavit in opposition running to about 1,000 pages has been handed over to him by the respondent last evening. First up, accordingly, comma, in order to get the petitioner to file affidavit in reply, comma, learned counsel seeks an adjournment till the next circuit. Push up, the time for filing affidavit in reply is extended for 3 weeks from date. Push up, let the matter be listed in the next circuit.
Oblige, my lord. This was item 5, I think, lord.
5, right.
Oblige, if you can.
101, yes.
Hearing matter which would take time. The spoken to Mr. Kormukar already. I have spoken to Mr. Kormukar already. He had some difficulty in this matter, this particular matter on the previous occasion that is recorded by your lordships. My interim order is expiring this week. So we were just discussing if the lordship would be pleased to extend the interim order.
We'll keep it as to be for extension tomorrow. And pass it. Okay, this will appear as to be for extension tomorrow.
Even if it appears as to be mentioned, because he will not be able to appear. He has some difficulty in that.
For extension, we'll keep it at under the heading for extension and extend, and then direct it to be restored to the listing.
And so far as item number 25, I was praying yesterday, we just about touched it.
Yes.
There is a bit of urgency in the matter because of the long pendency of it. Today, in the event it does not reach, I pray for upgradation of that matter tomorrow.
Well, if it is not heard today, 25th it has in Arich for
25.
25. But the new motions are there, Mr. Garbage.
This motion is also a new motion. And when it appeared initially, my lords wanted to hear the state before granting my interim order. Thereafter, the state was served. Thereafter, the state has not been able to.
So if you can't reach it, it will appear under the heading talks tomorrow.
I'm very
You can't talk with it. Yes. Any other mentioning? Call on the list. Sorry, Mr. Jaipur. Accordingly, SA 8 of 2026 is dismissed on contest, thereby affirming the impugned judgment and decree dated December 12, 2023. The details of the judgments. No rise to cost. Formal decree be drawn up accordingly. Trial court records be sent down immediately. Interim order, if any, stands vacated.
Item number 2. Procurement one administration what is here? The arrangement. Last occasion also I mentioned on 9th October, this one was passed and ordered.
Not yet come. Department के office के direction दीजिए एक report दीजिए record district. Learned counsel for the appellant submits that despite a previous direction dated February 9, 2026, the trial court records have not yet arrived before this court. Push up, the office is directed to furnish a report as to whether the trial court records have arrived. Push up, the matter be listed next on April 23, 2026 under the heading to be mentioned for passing further orders. Immediately office বলে দেবে আজকে যেন রিপোর্ট করে কালকে পরশুদিন থাকবে। Yes.
Item number 4. He was 6 of matter.
Yes.
By challenging the maintainability of this video.
Why not maintainable? Why not maintainable? According to you?
First of all, this person was not a party before the trial court and management court. Secondly, my lord, this is a case with regard to compensation due to the death of a deceased.
No, maintainability has to argue first.
A person died. When he died,
So don't touch the merits of the matter, Mr. Kumar.
no, I am not touching. I am saying, my lord, a person died, a motorcycle claim was filed, award was passed, this court came, this court modified the award. Now, this petitioner claimed to be brother of the said deceased. He filed this review application before this court. First of all, my lord, this application, no leave application was filed. There is a delay of more than 3 years. No condonation of delay application was filed. Lastly, my lord, under order 47, a person ought to be a person aggrieved. And my lord, under the law, my lord, the brother sister comes and because we are Hindu, schedule 2. They are schedule 2. Yes.
You are.
I appeared for the.
What is your relation with the
My
deceased?
relation was I was stepmother of the deceased, and my lord, I think somebody is appearing for the wife also. I am because married man. I'm there. So correspondent number 2.
So you are the first class heirs. You are the first class heirs.
Trial court allowed in my favor. My lord has modified the order saying that wife because
Let
wife,
us hear the petition on these.
Fine.
First of all, time bar. Secondly, that you are not a party, no leave has been sought.
and it's not a person agreeing, my lord.
That is the third.
Yes.
Yeah, I do not understand who is appearing to the respondent.
So what you
Mr. Gaikwad is saying that he is appearing for respondent to.
No, I am appealing for respondent number 4.
Who knows?
No, I am appealing for respondent number 4.
what about the time bar? Time bar leave. What is your answer?
I was not the party.
Then you have to file a formal application for leave, and that is referable to an appeal. Review. How can a review lie in the at the base of a third party?
I have a judgment that Indian award or order obtained by committing fraud. Review lies.
Oh, you say you take it to the level of fraud. And what about this condonation of delay? 3 years.
Not the party before they.
So yeah, limitation goes.
Limitation will not apply.
No, limitation is 30 days from the date of the order, not knowledge. So what?
I was not aware of this.
Please listen, then answer. Review limitation begins from the date of the order, not the date of knowledge. So whether you were a party who had knowledge is totally immaterial. Date of the order, you have to file an application. Please file a proper application for review, for condonation as well as leave. The counsel appearing for the respondent number 4 rightly points out that the present application for review is time barred. The counsel for the respondent number 4 rightly submits that the application for review is time barred, having been filed about 3 years after the order sought to be reviewed. So secondly, it is contended by the respondent number 4 that the petitioner was not a party to the original proceeding and as such has to cross the threshold of leave being granted by the court in order to maintain the review application. So thirdly, the petitioner, not coming within the class 1 heirs of the deceased victim, is not an aggrieved party. Next para. Insofar as the third ground is concerned, the same somewhat touches on the merits of the review application. However, since the review application is palpably time barred, having been filed much beyond the period of the limitation period of 30 days from the date of the order, and since the review applicant was not a party to the original proceeding, the same cannot be entertained without an application for leave. Next para. Accordingly, on the prayer of the review applicant, leave is granted to the review applicant to file an appropriate application for leave as well as an application for condonation of delay in filing the application. We are putting it in the next second.
Your Lordship, one submission, Your Lordship. Respondent number 3 therein is not the party to the original proceedings. The advocate has been agreed.
They have been arraigned.
We'll consider that. That only once they cross this threshold, then we talk.
Your Lordship, I pray that this circuit only, Your Lordship, because the regime.
Oh, you got my order?
Yes, by your lordship. My lord's order. Let it go on Monday. I will.
Well, let the matter be listed on April 27, 2026. Then it has to come before the second. Yes, next.
Item number,
6 out.
yeah, is in line of 26.
But I appear for the petition.
Yes.
So I am the result. Starting may some bail application.
Yes.
Maybe fix 2 months proceeding. Case has already been charged.
The evidence is going on, I last 2 years.
CD you can produce by tomorrow.
No. The evidence going on because the position I have.
On the prayer of the respondent state, the matter is adjourned for the day. Which of the CD, the case diary be called for in the meantime.
Out of 6, 5 have already been granted.
So on the ground of parity, we
My
will.
lord.
But let him come prepared.
My lord.
It has to be a meaningful hearing, you
My
say.
lord. My lord.
Yes.
Sorry.
Thank you.
Number 7, 21 of 26.
For family petitioner.
Yes.
For the response.
In a trial, at the first instance, the learner.
Mr. Jayapal, you come this side, otherwise it was. Not this side necessarily, but closer to the port. Yes.
The trial, being an accused person, I have been at the first instance.
Then you come this side because the other side will go far. Yes. Come to the center, both of you. So that we can throw things at you if you are first.
I have been acquitted.
Yes.
But the judgment was carried in appeal by the state before this session court. The acquittal order was reversed. I've been convicted. The order was challenged before this court. This court have set aside the order of learner session judge as well as the trial court's order, and the matter was remanded back to the trial court with certain rider. The rider was lost when the trial was taken place. The government examiner who held that the disputed sign and the sign which was admitted is there is a disparity and have been held conviction on that ground was not been cross-examined before the trial court session. This court said
Who was not prosecuted?
the P2D, government examiner question document. He submitted certain reports before the trial court because the prosecution has resorted to this exercise that the signature, because the entire matter relates to an agreement and signatures appearing there. The prosecution case goes to this fact that I have personated the signature of a lady, de facto complainant. So they have brought the report on record before the trial court, but I had no opportunity to cross-examine the expert body. Then this court, by setting aside the order of the substantive as well as the trial court order, remanded the matter before the trial court, which is specific direction, allow the accused person. First of all, prosecution has to secure attendance of examine expert body before the trial court. Then I have a right to cross-examine. That exercise was undertaken before the trial court on the matter being remanded back. So on a particular date, when I was supposed to be examined under section 313 CRPC, my examination was duly recorded and I have been given an opportunity to adduce defense evidence by the trial court. So moto, rather, the prosecution have filed an application before the trial court again to recall that order by virtue of which I have been given right to lead defense evidence. The trial court, in derogation to section 362 of CRPC, did not look into the language couched with section 362 CRPC.
That was it.
There is no power of review under CRPC, like CPC or 47. Once there are certain limitations, clerical errors, arithmetic errors, those can be modified, but review cannot be done. In one hand, at the first instance, the trial court have allowed me to produce defense witness by order impugned. That was recalled, and the matter was straight away posted for argument.
Let us see the impugned order.
My lord. Immediately before the Wakalatnama is certified, I have not calculated it, my lord.
This is order dated 24th of February.
Yes, ma'am. I will allow to place this order.
Yes.
Today is fixed for passing order. Record is taken up for passing order. Peruse the case record thoroughly and order passed by the Honorable Court. The Honorable Court, by passing the order regarding this case, was pleased to direct
The case record along with the lower court record will return to the Court of London Judicial Magistrate Porter on remand with a direction that an opportunity given to the petitioner accused to examine / cross-examine the government examiner of question document and pass a fresh judgment on the basis of evidence on record within 3 months from the date of communication of this order. In compliance of the order of the Honorable High Court, opportunity was given to the accused of this case to cross-examine the government examiner of question document, and after such cross-examination, the accused was also examined under Section 313 CRPC in respect of the newly deduced part of evidence. And at the end, the examination under Section 313 CRPC, the accused.
I've read the order. Please,
Yes.
please come to the High Court's order.
My lord.
Yeah, একটু second. এটা আবার ঠান্ডা করে দিয়েছে।
Just something.
Let's do it.
It starts at page.
Yes.
This one. It starts at page 117 of the application, marked as Annexure PA.
Yes.
Page 123 is the finding arrived at by this court. Paragraph 12, page 123.
Yes.
Having considered the arguments advanced by the learned advocates for both parties, the materials on record and the impugned judgment, I find that the report of handwriting relating to the question document has been marked as Exhibit 20 after objection. The accused person did not have the opportunity of cross-examining the witness to bring out the discrepancy regarding the questions document. Exhibit 19 under Section 293 of CRPC report, if it is think fit, summon and examine any such expert as to the subject matter of any report. In the present case, though objection was raised at the initial stage and the petitioner wanted to cross-examine the expert, the attendance of the witness was not enforced. In Section 294 of CRPC, there is a rider in subsection 3 which lays down that where the genuineness of any document is not disputed, such document may be read in evidence in an inquiry, trial, or other proceeding under this court without proof of signature of person to whom it purports to be signed, provided that the court may in its discretion require such signatures to be proved. It may be therefore gathered from the provision that if the genuineness of a document in question is disputed, it is essential that before considering the contents of such documents or the report of the expert as substantive evidence, an opportunity should be provided to the accused person to cross-examine the expert. Needless to say that the question signatures are the matter in issue which have been produced by the petitioner as genuine. Therefore, the petitioner has the onus under Section 106 of Indian Evidence Act to explain how he came to possess Exhibit 19. In such a case, there is no requirement to examine Kiran Chandra Paul and Krishna Poddar, who are said to be the witness in the said document. In this context, I would be opposite to place reliance upon the decision of the Honorable Supreme Court reported in 2009 SCC 286, which categorically stated that the expert opinion cannot be relied upon unless the expert is examined. In view of the legal position, I am constrained to hold that the impugned decision of the learned session is liable to be set aside, with the direction of the learned trial court to examine the examiner of question document who has issued certificate which has been marked as Exhibit 20. The revision application is allowed. The judgment and sentence passed by the learned session judge in criminal appeal number 7 of 2019 dated 30th of September 2021 is set aside. It is also made clear that the judgment of acquittal passed on 29/2019 in GR case number 3844 of 2015 by the Judicial Magistrate Port Blair is also set aside. The case record along with the lower court records is returned to the Court of London Judicial Magistrate Port Blair on remand with a direction that an opportunity may be given to the petitioner accused person to examine or the cross-examine the government examiner of question document and pass a fresh judgment on the basis of evidence on record within 3 months from the date of communication with God. Upon remand, my lordship, the gentleman was called. He was subject to cross-examination. The trial court, lordship, after I've been examined under Section 330, fixed a date for evidence, defense evidence. Then upon an application being filed with the prosecution, that order was recalled.
What is that previous order?
Well, not would find previous order.
not specifically recalled. It's not mentioned that it's recalled.
Just one second. It's recorded as for DW, Lordship. I'll show that.
No, in the impugn order, it's not recorded that that order is recalled, but effect is there.
The effect is same, Lordship, because once my scope has been closed, meaning thereby that order has been recalled. I'll just show that order. Yes, Lord. It's order dated 11th of February 2026, order number 165 of the learned trial court. When I was subject to examination under section 330. Today is fixed for examination of accused person under section 313 of CRPC. Accused person namely Swapan Kumar Datta is physically present by filing Hasira. Accused person namely Swapan Kumar Datta is examined under section 313 of CRPC in Hindi language, and after giving statutory cautions that he is not bound to answer the question asked to him, and if he should answer, it might be used against him in this case.
In the first round of litigation, you did not adduce evidence.
No.
So can you reopen that opportunity? When scope of remand is involved, it's an open remand.
It's statutory right, because when this court has remanded the matter, the court.
Suppose there was no remand, you would not have that opportunity. I mean, can it be reopened? Because this remand is only on the limited ground that you failed to have an opportunity to cross-examine the expert.
Yes, sir. But this court, while directing the learned trial court to rewrite judgment, after I have a right to cross-examine the expert, my right remains intact. It's my legal right under section to deduce defense witness. Kindly see the language clause under section 362 CRPC. When the trial court have already given a chance to me to deduce defense witness, how this could be recalled? It's affecting right. I could have understood there's some clerical error under the garb of 362. Those can be gone into by the same court. It's not like CPC, Lordship.
It is 362.
No, 362 CRPC.
Uh, 362 is on a different footing, like 152 and now.
My argument is, Lordship, the trial court could not have passed the impugn order. Moreover, Lordship, this court, while remanding the matter, have not precluded me to produce defense witness. There is no finding arrived at. Simply, trial court was directed, allow the accused person expert body. Once that is done, rewrite the judgment. That there nobody has been precluding my client can't adduce. This was appreciated by the trial court at the first instance because the scope was revived after I been examined under section 330 CRPC. But by order impugn, that has been shut down, Lordship, and the matter has been posted for argument. So I blame Lordship.
All right.
I will reduce my evidence, that's all.
Let us hear the answer. Yes, yes, yes.
See, para 15 of the judgment that passed by this honorable court.
Yes.
Remanding back on limited scope. Lordship, remanding back to the trial court. Point was decided by this honorable. Page number, Lordship.
Yes.
124.
Yes. But it was an open remand because the court did not restrict it to that.
No, Lordship.
See the language.
Lordship, in view of legal position, I am constrained to hold that the impugn decision of the learned session judge is liable to be set aside with the direction upon the learned trial court to examine the examiner of the question document who has issued a certificate which has been marked as Exhibit 20. One expert opinion was not called. That person who has issued it not called. On that ground, they preferred challenge. Only on that limited purpose, that opportunity should be given to the accused to cross-examine that.
Because that was the ground on which it was set aside. But in para 16, it is set aside as a whole. It is not remanded to a limited extent that restricting him to only this.
Well, restriction is.
Otherwise, by that logic, 313 examination could not also be done.
I am coming to that. I am done. Lordship, trial evidence examination of the evidence completed before the criminal court. That fixed for 313, the statement of the accused by the court. 313 statement, Lordship, as I know, it is in respect of the evidence which is against him. Entire story cannot be put it to the accused under section 313 CRPC that this is happened. No, a specific questions has to be put by the trial court during 313 that these are the evidence. This witness said against you.
But if the logic is accepted, then only it would be what would be the scope of the remand? That only he would be permitted to cross-examine over shut.
Lordship, because.
So no 313 also. That
That
will be a too high.
No, Lordship, 313 in respect of 330, second 330 has to be done. That was done accordingly because questions document was cross-examined. In that effect only 313 was required. Second time 313. Only for that purpose. Then 313 completed questions of adducing DW cannot be in the trial court, Lordship, because 313 already accepted at the time of comments during trial. So limited scope para 15 clearly stated opportunity only to cross-examination. Then suppose 313 was not conducted. That it was illegal.
So you say 313 was in the context of that document being examined.
Only that part. Otherwise, that was bad in law. 313 in respect of cross-examination to the expert. That part was done by the trial. Then why again DWs? Because DW's opportunity was given first time, then he was convicted. It cannot be, Lordship.
Take them.
362 totally different.
Passing on. Yes. Stephen. The present revisional application has been preferred against an order whereby the learned judicial magistrate, FC hyphen 1 or 2?
1.
1. On the prayer of the learned additional public prosecutor, allowed an application of the prosecution, thereby holding that in the absence of any specific order, there is no scope of adducing further DW in the case. So next para, learned counsel for the petitioner argues that the background of the case is that initially the criminal prosecution, the criminal trial culminated in acquittal of the petitioner / accused. The same was reversed in appeal, against which a revisional application was preferred before this court. While deciding the same, vide judgment dated April 29, 2022, a learned coordinate bench of this court remanded the matter with a direction to grant opportunity to the petitioner / accused to examine / cross-examine the government examiner of questioned document and pass a fresh judgment on the basis of evidence on record within 3 months from the date of communication of the order. So next para, it is argued that while permitting the petitioner to cross-examine the government examiner, the learned single judge did not restrict the remand order to such cross-examination only, but had set aside the entire order of the entire judgment of the learned sessions judge and sent the matter in an open remand. Next para, in the absence of any such preclusion of the petitioner, the learned judicial magistrate acted without jurisdiction in closing the independent defense witness sought to be adduced by the petitioner. So next para, secondly, it is argued by the petitioner that there is very limited scope of altering an order, once passed by the criminal code. Section 362 of the Code of Criminal Procedure 1973 stipulates that no court, when it has signed its judgment or final order disposing of a case, shall alter or review the same except to correct a clerical or arithmetical error. Next para, it is submitted that the application of the prosecution before the judicial magistrate was not of the nature as covered by section 362 and substantially, comma, the learned judicial magistrate recalled his earlier order bearing order number 165 dated February 11, 2026, comma, by which the next date was fixed for adduction of evidence as DW2 by the present petitioner. So next para, thus, comma, it is contended that the impugned order ought to be set aside. So next para, learned public prosecutor, learned public prosecutor, comma, while controverting the arguments of the petitioner, comma, submits that it will be evident from the remand order itself that it was passed on the limited count of the petitioner having been deprived of the opportunity to cross-examine the government examiner of question document, comma, since the document in question was germane for adjudication of the matter. First up, however, comma, it is pointed out that the petitioner, comma, after sought to expand the scope of the remand by seeking to adduce independent evidence, comma, which was not permissible in terms of the review order. Remand order, sorry, remand order. Next para, it is further contended that although the petitioner was examined under section 313 of the Code of Criminal Procedure, comma, such examination was limited to the context of the fresh evidence which was laid on the questioned document by the cross-examination being done by the petitioner. However, comma, it is contended that such limited examination under section 313 did not entitle the petitioner to reopen the entire trial by adducing independent evidence, comma, having already lost the opportunity in the first round of litigation. So next para, upon a perusal of the impugned order, comma, it is found that the learned judicial magistrate did not specifically recall or review the order dated February 11, 2026, whereby the next date was fixed for evidence of the defendant's witness. Next para, by the order dated by order number 165 dated February 11, 2026, comma, no specific adjudication was made on the question as to whether the petitioner was entitled to lead independent defense witness, but the learned judicial magistrate, comma, merely in a judicial magistrate had merely fixed the next date for adduction of defense witness on the prayer of the petitioner. Next para, thus, comma, this court does not find that any jurisdictional error was committed by the learned judicial magistrate by observing in the impugned order that there was no scope of adducing further evidence. Next para, even otherwise, comma, it is inherent, the power is inherent in any court of law to rectify its records in the event the court commits an error which is apparent on the face of the record, comma, irrespective of whether it is in connection with a criminal trial or a civil proceeding. Seen from such perspective, comma, merely because the learned judicial magistrate, comma, effectively, comma, negated the earlier order dated February 11, 2026, comma, it cannot be said that the magistrate lacked inherent jurisdiction to correct its earlier position if there was a glaring error on the face of it. Next para, the next question which crops up, comma, obviously, comma, is whether there was any such glaring error. Next para, upon a careful scrutiny of the remand order dated April 29, 2022, passed in CRR number 15 of 2021, comma, it strikes the eye that in paragraph number 17 thereof, comma, the learned single judge had categorically observed that the matter was sent back on remand to the judicial magistrate, comma, Port Blair, with a direction that an opportunity may be given to the petitioner stroke accused to examine stroke cross-examine the government examiner of questioned document and pass a fresh judgment, double inverted, quote unquote, on the basis of evidence on record, double inverted close, within 3 months from the date of communication of the order. Push up next para. The expression, double inverted, on the basis of the evidence of record, double inverted close, clearly meant that the adjudication had to be made on the basis of the evidence which was already on record on the day of the order of remand, and the limited scope of the remand, comma, although couched in the language of an open remand, comma, was to grant an opportunity to the petitioner to examine stroke cross-examine the government examiner of questioned document. Push up next para. Section 313 of the Code of Criminal Procedure, comma, as rightly argued by learned public prosecutor, comma, operates in a limited scope, comma, for the purpose of enabling the accused personally, double inverted, to explain any circumstances appearing in the evidence against him, double inverted close. Full stop. The occasion to permit examination of the petitioner under section 313 evidently arose in view of the further cross-examination made by the petitioner in respect of the government examiner, comma, which was required in law to be undertaken. However, comma, the exercise under section 313 of the Code of Criminal Procedure could not justify throwing open the trial afresh, comma, after the petitioner had already lost his opportunity to adduce independent witness as defense witness in the first round of litigation. Push up next para. Seen in the above context, comma, the learned judicial magistrate was justified in closing the evidence and not permitting the petitioner to initiate a de novo trial by adducing independent evidence as DW in the case, comma, which would be beyond the scope of the remand, comma, particularly in the teeth of the fact that the petitioner had already lost such opportunity in the first round of litigation. Push up next para. Accordingly, comma, I do not find any illegality or jurisdictional error in the impugned order. Push up, hence CRR 21 of 2026 is dismissed in contest, comma, thereby affirming the impugned order bearing order number 168 dated February 24, 2026, passed in GR case number 3844 of 2005 by the judicial magistrate within bracket FC1, comma, Port Blair. Arjun sir.
Item 8. PO 25 of 2026.
I have a question.
Yes, Mr. Halder, what is the matter? Is there any caveat in the matter? Oh, that matter, yes, sir.
Well, there,
Yes.
they have purchased a land from the defendant.
Right.
That's what happened.
All right.
After purchase, I have paid the entire consideration amount. Land was handed over. After taking over the possession, they have constructed my residential house.
There's a registered sale deed, regular.
No, agreement.
Agreement.
for sale. Agreement. for sale.
Handed over pursuant to that.
Yes, I have constructed my residential house. I have obtained the electric connection in my name. I have obtained the water tap connection in my name. I'm enjoying. as because the defendant did not come forward to register the sale deed, I went to the house of the defendant.
The agreement for sale was registered.
No,
Nothing. You went to the house, yes?
Yes. the defendant was not present. His children were there. They said, my father told that he will not execute any registered sale. I filed a suit for specific performance of contract. Summon was issued to the defendant, but before service of the summon, the defendant shifted his residence. So report has come, summon returned answer. Then I am not aware of the present address of the defendant. I filed an application under order 5/28 of CPC for alternative service of summon through paper publication. My application was allowed. The summon was published in the local newspaper. Nobody come forward, suit was proceeded expert.
Right.
I have examined 5 witnesses, including the plaintiff number 1, 2. There are 2 plaintiffs, husband and wife, jointly purchased the land. And there are 3 attesting witnesses of the sale agreement. I called them also. They have admitted their signature, execution of the sale agreement, handing of everything, payment of consideration and everything admitted. Initially my suit was dismissed on the ground that at that point of time, because some mistake, I could not able to produce the record of right of the subject. So the trial court held that the plaintiff failed to produce the record of right to show that at the time of execution of the sale agreement, the defender was having good title to transfer this property. On that ground only, even my agreement was admitted, everything was admitted. On that ground, suit was dismissed. I filed the first appeal. My first appeal was allowed. In the first appeal, the first appellate court appeal was allowed and remanded back the matter to the trial court and directed the trial court to give an opportunity to produce that document. And when I filed the application, I find that during this span of time, the survey number of the land has been changed. The bifurcated number has been given. Earlier it was 45/2. Now the survey number of the suit land is 45/2/8. So immediately I filed an application under Order 6 Rule 70 for amendment of the claim. My application was allowed. I filed the amended claim incorporating the new survey. Thereafter, I have adduced the evidence. I have produced the documents. The record of right, it was exhibited also, and it was fixed for argument. I have argued the matter. In the trial, the first appellate court directed the trial court to give opportunity to adduce further evidence and pass judgment afresh on the basis of the material of record. And my lord, kindly see the input order. There was no record that the defendant died. From where the learned trial court found that the defendant died, and I have been directed to take appropriate steps to bring the legal heirs of
There's nothing on record.
No.
What are you saying?
No.
What are you saying?
Here.
How could it? Let us see the order.
So, yeah. May I read to
The relevant portion you can read. First paragraph need not be read.
second page, both the PW.
This was at the final hearing stage, argument stage. It was going on. It was going on ex parte.
I have argued the matter. The learned first appellate court says so on the basis of the material record, pass it.
No, in your PW1, in your evidence, you have stated
Further construction arrow certain sir, when the legal heirs of
the legal layers. You use the expression legal layers.
to register sale deed in respect to the suit land in favor of the instructed by the defendant.
So why did you use the expression legal layers? How can the legal layers?
Children.
How can the children execute if the person is living?
Children are also legal.
If I am living, how can my heirs execute a deed?
No. When I went to the house of the defendant was not present.
Your
Defendant instructed the legal heir that he will not execute the sale deed.
but your evidence read further cause of action
Sale
and
deed.
when the legal heirs of defendant refuse to register sale deed.
As
Yes,
instructed by the defendant.
So what is the question of the you created the complication in your evidence? Where is the question of legal heirs registering a sale deed?
No, legal heir will not register sale deed.
That is what you have said.
No.
Defendant legal heirs refuse to register sale deed.
Because to register sale deed in respect to the suit land in favor of us.
So how can the legal heirs register the sale?
Instructed by the defendant Defendant.
Have you annexed that part of the evidence?
Yes. Even in the plaint, I have stated the same thing.
Let us see the plaint.
Yes. Page number 43. Paragraph number 14. That the cause of action for filing of the suit arose within the jurisdiction of this honorable court, where the suit property is situated on 16/7/1997, when the plaintiff purchased the suit land from the defendant through agreement for sale, and further cause of action arose on circumstance when the plaintiff took possession over the suit land, and further cause of action arose on 18/11/2015, when the legal heirs of defendant refused to register sale deed in respect to the suit land in favor of the plaintiff as instructed by the defendant.
The present divisional application served copy. You want a stay of the?
I do not know the address. I will search through paper
Oh yes, right.
because proceeded expertise.
Very good. Very good. The present divisional application has been filed against an order whereby the learned trial judge directed the plaintiffs to petitioners to implead the heirs and legal representatives of the defendant stroke opposite party. Push up learned counsel for the petitioner argues that it was never the case of the plaintiff stroke petitioners that the defendant has met his demise. Pushed up in the plaint, it has been categorically alleged that the defendant is liable to execute and register a proper sale deed in respect of the suit land in favor of the plaintiffs, but even after receiving full consideration amount and after several requests, the defendant is not coming forward to register sale deed in favor of the plaintiffs. According to the plaint case, when the plaintiffs finally went to the house of the defendant, he was not home, and his legal heirs refused to register sale deed in respect of the suit land in favor of the plaintiffs, as instructed by the defendant, the same statement was repeated in the examination in chief of the plaintiffs, taking a cue, CUE, from the said expression used in the examination in chief, to the effect that the legal heirs of the defendant refused to register sale deed, apparently the learned trial judge proceeded on the mistaken notion that the defendant has met his demise, which is beyond the plaint case altogether. Next para. In such view of the matter, this court is of the opinion that a sufficiently strong arguable case has been raised in the revisional application as to whether the learned trial judge exercised jurisdiction not vested in him by law by directing the plaintiff to implead the heirs and legal representatives of the defendant stroke opposite party, despite the plaint case being categorically that the defendant is still alive. Next para. Since learned counsel for the petitioner submits that the defendant could not be served with the summons of the suit, and substituted service had to be effected, as he has left his last known address, learned counsel seeks liberty to effect service by the mode of substituted service in respect of the revisional application as well. Accordingly, the petitioners are directed to effect substituted service on the defendant stroke opposite party by publication of notice in a newspaper in two newspapers, one in English and the other in the vernacular language of the defendant opposite party, in the area having moderate circulation, at least moderate circulation in the area of the last known address of the opposite party within a fortnight from date. Next para, an affidavit of service to that effect shall be filed on the returnable date. The revisional application shall next be listed before the appropriate bench in the next circuit, push-up, there shall be stay of operation of the impugned order as well as all further proceedings in yes.
Other suit number 23 or 20.
Best. In other suit number 23 of 2020, pending before the learned civil judge, bracket junior division, bracket closed, hyphen Roman 1, comma, Port Blair, granting for a limited period your own suit, stay for a limited period or till disposal? Till disposal of the divisional application. Let it be called on. Call for. Let it be formally called on, yes.
No, because
কল করো ফোরটা মনোজকে বলছি
item 4, if you 6 of 26.
yes what is the matter
Pilot already fixed on 27. Second last day of this circuit. Pilot to prepone the date on 20.
fixed on 27 means
Pilot already fixed it on 27. Pilot has taken up to that. Pilot was taken up, pilot fixed it on 27. So I am praying for preponing the date on 20.
why did I adjourn it on your prayer
Namely him to file section 5 along with the review application. So especially about the limitation.
oh sorry Manoj sir it's already call হয়ে গেছে why can you do it before that
Yes, yes. On Friday, I don't suppose pilot is filing, then we have to file our reply also.
what reply section 5 leave reply will not give you the option
I am temporarily preponing it. Instead of 27,
It's a very well.
22.
4 এ যেটা দিয়েছি স্টিফেন ওটা 27 না করে ওটা মেক ইট 24th এপ্রিল 24th item 4 এ yes
Your 26 of that.
Thanks for the.
what is the matter Mr. Prasad
My survey number is 34/1/40.
all
Very,
right
very important matter, kindly take note. 34/1/40.
Right.
The survey number of the plaintiff is 34/1/50.
all right
Adjacent plot holder. The plaintiff encroached my land. And constructed a house also in that place in my land. I initially approached the Tahsildar. Tahsildar passed an eviction order. It was not executed. I approached the Honorable Single Bench in the year 2016. The Honorable High Court directed the Tahsildar for implementation of the said order. The plaintiff's wife filed appeal against the writ petition. Mandamus appeal before this division bench, Honorable Division Bench. The Honorable Division Bench, my lord, did not interfere with the order passed by the Honorable Single Judge. Directed the Tahsildar to give opportunity of hearing to the plaintiff. Thereafter, Tahsildar passed an order for evicting the plaintiff from my property.
no you are going on saying plaintiff the suit was filed by whom
Plaintiff,
you say you filed an eviction suit
that is before Tahsildar.
Acha, this plaintiff is subsequent
Yes.
Acha, then let us hear after that
Thereafter, my lord, the plaintiff filed a civil suit for permanent injunction against me by encroaching my property. I contested the suit. Suit was dismissed.
eviction proceedings have to be initiated under the laws here before the Tahsildar
Yes.
yes
161.
so filed a suit for declaration of his title or what
No, permanent injunction.
only permanent injunction,
Only permanent injunction.
without disputing title
That's not the question of disputing title. Because he encroached my property,
so in that what happened
that suit was dismissed. Based on the commissioner's report, the assistant commissioner's suit was dismissed. The plaintiff filed the appeal. First appeal before the land district judge. Appeal was also dismissed. Then the plaintiff filed second appeal. That was also dismissed. Thereafter, again I approached the Tahsildar. Kindly see, the Honorable Division Bench also dismissed, evicting from the property. Tahsildar passed an order for eviction of the plaintiff from the my land property.
And he was given an opportunity of hearing.
Yes. Again, that order was challenged by filing a petition.
I have already forgotten. Start from the beginning. So then what else?
7 rounds of litigation, my lord.
If come with a list of dates.
I
So
from the-
7 rounds. How
7
many rounds are over already?
My lord,
You have already completed how many rounds? 3.
this is 8th round,
No, no. Now in your submissions you have covered up to which round?
only 3.
I'll forget. Please bring a list of dates. What happened ultimately? What did you do?
2 minutes time may be given, I will submit.
No, it's my problem that I'll forget, not your problem.
Tahsildar again passed on the eviction order, my lord.
Again, eviction order.
Yes, based on the order passed with the division bench.
Should have been implemented only. Yes.
My lord, that Tahsildar, the Honorable Single Bench again dismissed the petition. Again appeal was filed. Mandamus appeal. MNT 31 of 25. Again it was dismissed by directing the Tahsildar comply the order passed by the Tahsildar. Meanwhile, I also filed a petition before the Honorable Single Judge saying that I am out of property, out of my property, kindly restore my property. The Honorable Single Bench also directed the Tahsildar to implement the order passed by the Division Bench. By suppressing everything, the plaintiff filed another suit challenging the subdivision order passed by the Deputy Commissioner after 15 years. I raised the question of maintainability of the suit. Barred by limitation number 1, number 2 res judicata. At the time of hearing, the Learned Civil Justice Senior Division submitted in open court, suit is not maintainable. I am going to frame a preliminary issue whether suit is maintainable or not. It was fixed for order for 20 days. After 20 days. After 20 days, a shocking order was passed. Status quo was granted. This is shocking, my lord.
Status quo, Mr. Prasanth, you have to prefer a miscellaneous.
I find miscellaneous appeal.
That was.
The stay was not granted. So I am before your lords. I will go one by one. My lord, kindly come to.
No, if I grant stay at this point of time,
My lord.
this definitely requires hearing. I mean, should be admitted.
Yes. Because my lord, I filed contempt also for non-compliance of the order passed by the division bench.
No, no, definitely.
That
have to go
contempt is coming on 24.
without hearing the other side, we cannot.
Well, stay is required.
Past stay, that will be the final relief before hearing you.
No, stay for a limited period. I will serve upon the learned counsel who is appearing before the trial court.
If I grant stay, that will be allowing the revision application because you have challenged an order whereby stay was not passed. The stay was not passed.
So, and then I will serve upon the learned counsel who for the plaintiff who appeared in the court below.
I'll direct both and or. So if you can serve either the opposite party or the counsel, then I'll take it.
Well,
How soon can you do that?
Fixed day after my lord,
You're looking at the clock. You can do it today itself.
Yeah.
You're looking at the clock.
I try to serve today itself if it is upon the council.
Who are the private respondents? All of them.
Mainly the
Plain.
opposite party number 1.
The present matter has a check.
My lord, one submission.
Yes. Yes.
My lord, the Learned Civil Justice, I'm very sorry to make this submission.
No.
The Learned Civil Justice Senior Division, my lord, committed, my lord, grave error, grave injustice to me. This is judicial indiscipline, my lord. He is not accepting the order passed by the division bench. Or not 1, 3 division bench order is there, my lord. How he can pass the order? I am failed to
No,
understand.
there are several judgments which say that stay of an injunction or of a restraint order is generally not passed at the ad interim stage
Yes.
of appeal. Might be that. Might be.
Sir, only one document I want to show.
But
my
the
lord,
the court of first instance, you may have a point there. Should have.
my lord, kindly, I want
No,
to.
you have not annexed the first court's order. No.
My lord,
The
every all order I enclosed.
where is the trial court's order which was challenged before the district judge?
It is at page.
Page 142 is that order.
Yes, my lord. Starts from 136.
Or temporary injunction is there. The matter has a checkered career. Push up next paragraph. The counsel for the petitioner argues that there were at least 7 previous rounds of litigation and the petitioner had to run from pillar to post.
I'm widow, my lord, 67-year-old widow.
One of you. The petitioners had to run from pillar to post to get their rights vindicated. Full stop. At the first instance, comma, the plaintiff stroke opposite party number 1 encroached upon the property of the petitioners, comma, upon which a proceeding for eviction had to be taken out before the Tehsildar, which culminated in an order of eviction being passed against the opposite party number 1. Full stop. The opposite party number unsuccessfully challenged such order before several forums. Full stop. Even thereafter, comma, the order was not being implemented by the Tehsildar, comma, prompting the petitioner to take out appropriate applications, and thereafter a writ petition which was allowed, comma, directing the Tehsildar to implement the order of order of eviction. So next para, the order of the learned single judge was challenged before a division bench of this court, which affirmed the order in principle, comma, merely opening an opportunity of hearing for the plaintiff stroke opposite party number 1. To sub next para, it is submitted that even thereafter, comma, there were several rounds of litigation. To stop the opposite party number 1, comma, in order to frustrate the rights of the petitioners, comma, filed a suit for permanent injunction, which was dismissed by the trial court as well as the first appellate court, comma, which was affirmed in second appeal as well. To stop, even thereafter, comma, the plaintiff stroke opposite party number 1, comma, by raising a sham SHAM challenge after 15 years, comma, filed a suit afresh, comma, which was not only palpably time barred but malafide and non-maintainable on the face of it. First up, it is argued that in connection with the said suit, comma, the learned trial judge allowed an application for temporary injunction filed by the opposite party number 1, comma, against which a miscellaneous appeal was preferred by the petitioners. First up, by the order impugned hearing, comma, the learned district judge refused to grant ad interim stay of the order of injunction, temporary injunction, comma, prompting the petitioners to prefer the present revision. To the next para, upon hearing learned counsel for the petitioners, comma, it transpires that a strong arguable question has been raised in the present revisional application as to whether the learned trial judge was justified in passing the permanent injunction order, and stroke or whether the learned judge of the appellate court ought to have granted stay in the exceptional circumstances made out. Post up next para, accordingly, the petitioners shall serve a copy of the revisional application on the plaintiff stroke opposite party number 1, both by registered post with AD directly as well as to the learned advocate appearing for the plaintiff stroke opposite party number 1 in the trial court stroke first appellate court stroke appellate court, and file an affidavit of service to that effect on the returnable date. First up, next para, service of notice on the pro forma opposite party numbers 2 to 5 is dispensed with in view of no relief having been specifically sought against the said opposite parties. First up, when should I keep the matter, Mr. Prasad?
Friday.
Let the matter be listed next on April 24, 2026.
But only one page badly lost. Page 107. Only one paragraph. 107, paragraph number 2. After this also, my lord, status quo order was passed. This is
This
second one.
may be an exceptional case, maybe.
There are no cases made out.
No, maybe an exceptional case where stay at the inception might have been passed. Let us consider. Let us hear the other side.
Suit itself is not contained with that. Filed after 15 years.
No, the appeal may be ultimately allowed, your appeal, but the question is whether at the ad interim stage stay of injunction that would tantamount to allowing their. That is what we will consider. If they appear, the other side appears, then we can consider here only. Because they are hard then. Right.
Item 10, 027 and
Yes.
26. Number petition.
Right.
It's the final suit. Answer is a failed on the ground that the accessory property.
Pardon, on the ground that
Accessory property, that other property expired.
suit for what? Declaration of title.
Technical correction. Now, I find application of certain equivalent to injection application that was allowed by the trial court. And order was passed, and it comes to where the injection order at page number 61. The operative 62. Therefore, identity injection considered and allowed, all the parties are directed not to gradate and change the injection characters appropriately so and so day.
Right.
Now, subsequent order happened, the defendant, number 5, made an application to the executive engineer to disconnect the water application with device.
Water.
Yes, page 64. Made an application to disconnect the water passing of the order. To disconnect water tap connection. Based on that, it disconnected the water tap connection. I find application 151 to restore the water tap connection. That was rejected by the London trial court on the ground that he is not a party to this. Executive engineer. I am not clear relief against the executive engineer. What do I get a relief this? My only grievance is that it disconnected water tap connection. That's all. And you come to where that the impulse order, page number 2. The last paragraph.
You sought for direction on the executive engineer to restore the water supply.
Yes. What is observed that he is the necessary party, it should be added as a party.
No, not that maybe, but
Can you see my lord, it is there. It appears, can you see the second?
no.
It appears to the said order that no direction was given to the executive engineer to restore the water correction as ever with 20 in the state application. More executive engineer was not added as a party in the state case. The state application is only preferred in point number 5 but also executive engineer PhD. Considering the mandate of the natural justice ordering order partner before passing executive order with respect to the state application to engineer has to be heard.
No, why did they? I mean, what was the occasion? The water supply is in his name. The plaintiff.
Yes. The name of the dependent party. He knows that entry order will pass only to harass me. I will let him. I not stay there. Only to harass me. Find a period to discredit order correction.
No, but court has a point where the court can direct the executive engineer directly. There's an issue.
This is application made by the defendant. On his application, this was disconnected. It's not Sumoto.
No,
And in the suit, I am not.
no, suit you are not required to make.
Yes.
That I can appreciate,
Yes,
but because this was actually done by the executive engineer, not
Yes.
at his behest, maybe.
Yes.
You can take proceedings against him, and you can also think about giving you liberty to apply for an independent electricity connection or an
Water
independent water tap connection or from the same ferry. You may take a sub connection.
For last 4 months, I have got water. But orders of February.
Have you applied for independent connection? No.
New connection, my lord.
New connection?
Well, it is the name of my father. Property is the name of father. So cannot. He is my dependent against father.
Oh,
That's not apply.
serve a copy and come back. How soon can you serve?
All parties are there. It is
Next second.
it is more than
Oh, wow.
public fund. Different places.
Serve as soon as possible. We will
Well,
keep it next second.
well.
The petitioner has made out a strong prima facie case as to whether the learned trial judge was justified in diffusing the application of the plaintiff stroke petitioner, comma, in his suit for declaration and consequential reliefs, comma, for a direction on the executive engineer, comma, PHED, comma, APWD, comma, to restore water supply to the petitioner, which was disconnected by the executive engineer at the behest of the
Dependent number 5.
opposite party number 5
Yes.
of the defendant stroke opposite party number 5 in the teeth of a subsisting order of status quo, subsisting order of injunction full stop. Next para, accordingly, the petitioner shall serve copies of the revision application on the opposite parties, indicating that the matter shall be listed next in the appropriate bench of the next circuit. Further, the petitioner shall serve an affidavit of service to that effect on the returnable date. But the injunction was not regarding disconnection or enjoyment of possession or person. It was only in respect of alienating and changing nature. He has not.
It is correct. This thing I was there, like
I'll add a line. It is made clear that the pendency of this revisional application or the suit shall not come in the way of the petitioner applying for an independent water supply connection and so-called sub-connection in his own name, comma, if the petitioner is otherwise so entitled in law. Please explore the opportunities whether you have sub-connection can be taken under the law. This is an essential supply. Electricity you can, sub-meter can be taken, water I don't know.
Yes.
Item 11. WPA 152 was content decision.
She was there in the month. So not today or Passover. This is item 11. Passover. She comes.
The dual may not, I don't have any grievances against it, because Rakesh is there, dual can be taken.
Item 12.
She is a performer as far as but here, on the last occasion, my lord has passed an order.
Yes.
Where my lord has asked certain clarification. Owners to give the notification or the CS and notification.
Where is the bar, Mr. Kumar? Mr. Rakesh Kumar. Yes, sir. So otherwise,
There is a bar. Because he has to get a clearance.
Tehsildar had recommended.
But that, well, forest department has also clarified that not be someone in CS too.
But still, he because a pollution clearance certificate
Yes,
for.
yes.
So obviously should, because this is the coastal zone. These
Yes.
restrictions
He's
are
not
for that.
denied that he is not covered in the CSZ. No, no, he is coming under the CSZ. But for any activities in CSZ zone, you have to be even a business activities or performing any type of commercial activities. You have to get a CSZ clearance. As
There are 4 categories.
yes, yes.
This is 2.
He come under category 2. The forest authorities are verified and they found in the longitude and latitude and they said it's come under the category 2. And they also said they have to apply under the online portal for no objection NOC for if they verify and it is found to be not there, then they will give NOC and let us forward it to the pollution control authority and they will give us then no objection certificate for performance there.
Stone crusher units are not specifically covered. Under this, Mr. Rakesh Kumar,
Yes, sir.
this shows that something which covers stone crusher. ICRJ Z2 is covered at page 5. D. Let us see the dictionary and language.
Two, they are pollution control authority has given.
Stay. This is something else.
This is CSZ.
CRZ, this is IFZ. Let us check out. maybe IPZ. This is a particular notification. Yes, this is here also.
AMC have their name. This with regard to this common category of sales and
Stone crusher unit is not covered. Or anything of that sort, anything similar to stone crusher.
which notification is not in existence.
Why?
Or subsequently 2019 first notification came.
CRZ notification. I will have that.
Yeah.
Do you have that?
Yes, my lord. Should be. It's pure.
2019 has been, that's a notification. In the official gazette, it has come out.
Yes, my lord, it's a notification.
Yes, yes. It's a gazette copy of.
And my lord, if my lord sees page 29, the notification under which stone crusher unit is governed, my lord, it was framed under an act.
No, there may be overlap of different notifications covering the same thing.
But my lord, let him conclude, my lord, because I don't find any word stone crusher unit in either of the notifications.
It says not the prohibited activities, CRZ, the following are declared prohibited activities.
Yes.
With CRZ setting up of a new industry and expansion of existing industry is expected. We want to do a crusher activities, we are setting up a new industry.
Where is that?
Yes.
So the 2019 notification has come.
It is not in existence. It's not in existence. Once 2019 comes, it's not notified. It was notified. But what time? This is available. My lord.
Mr. Vinu Kumar, you please exchange copies of these notifications and come back tomorrow. I'll take it up tomorrow only.
One more thing, my lord.
Yes.
Environmental guidelines for stone crusher.
Whatever you want to rely on, give him copies
Yes.
and come back tomorrow. I'll take on record tomorrow.
Yes, my lord. This also was issued by the ministry, but confined to stone crushing unit. Here also there is no.
I'll take both on record tomorrow. Please take out extra copies.
I'm just giving a copy to my learned friend.
19 is not applicable for.
I will take.
Now, I have taken.
I have given an environmental guidelines for stone crusher unit issued by the Ministry of Environment.
At the time of hearing, learned counsel appearing for the respondent authorities seeks to rely on our 2011 coastal zone regulation notification. Mr. However, learned counsel for the petitioner submits that the same has been superseded by subsequent notification of 2019. So that apart, it is argued that the said notification does not govern stone crusher units. So next para, since learned counsel for the parties seek to rely on documents which are not a part of the record, counsel are requested to exchange copies between themselves of whatever documents they want to rely on. Kusab, let the matter be listed tomorrow under the same heading for hearing. Mr. Kumar, Mr. Rakesh Kumar, take this back. Whatever you have given, take back. Tomorrow you rely. You also ascertain.
Yes.
If that is not applicable, then we will not rely on this.
And my lord, I have handed over all the documents which I am going to rely on.
Yes, you ascertain, and you also hand over to him what you want to rely. 2011 notification must be there. These are available on the net.
This is 2019 is available.
We'll just give it back to you after having a taking up for that. Correct. Thank you.
Right.
Thank you.
Letter 13, WPA 167 of 2026.
Lord, I am appealing for the commissioner. It comes at the order of the court. My lord, I appeal your service.
You have taken control of my court, Mr. Kiran. Now, statistically, you should lose this matter. No.
My lord, here it's a very difficult case for me because this matter, my lord, this husband of this petitioner had obtained a bank loan near about 42 lakhs. Now, my lord, he was an employee under the Calcutta Municipal Council. My lord, they have three issues. All of a sudden, my lord, on 24th of May 2025, he succumbed to death. Once he died, my lord, thereafter these ladies don't have any source of income. Her husband was working as a mazdoor on regular basis under the municipal authority. And she has having three school-going children, my lord. And the loan was obtained for the purpose of construction of a building which was constructed.
Loan taken by the husband.
Husband during his lifetime, he has paid an amount of rupees near about 40 lakhs he has paid. But my lord knows that there is interest and all several amounts were there, my lord, which are to be paid. Now, once husband died, thereafter she was not given the pensionary benefit, nor she has been given appointed on compassionate ground. We filed a writ petition before this honorable court. This honorable court directed to release all the pensionary benefits, and this honorable court passed an interim order. Till her application is considered on compassionate ground, she may be given some work so that she can survive. Now, my lord, despite of the order,
Husband was working where?
husband was working in Port Blair Municipal Council as a regular mazdoor. Now, my lord, after the order of the court, subsequently they paid the pension amount. But so far as the interim order pertaining to her appointment, at least to survive, that has not been done. I taken out a contempt application which is now appearing before my lord Justice Dev, and my lord on Monday has passed an order directing them to give her appointment at least so that she can survive, and the matter is posted on Thursday.
The pension has been given to her already.
Pensionary benefit was given. Now pension she is getting 30,000 rupees, my lord.
30.
30. Now, my lord, the moment she got the pensionary benefit, my lord, in the midst of it, my lord, a notice was issued to her on 2nd of February 2026 under the Surface Act, saying that your husband has obtained this loan, you have to pay. Now, my lord, at that point of time, she was receiving no amount. She has not received the pensionary benefit also. My lord, thereafter, she made an application before the Lok Adalat and all, since the amount is higher, therefore it was not taken. My lord, once her pension was settled, my lord, she made an application before the authority on 30th March 2026, saying that this is the only house, we don't have any other place to reside. I receive an amount of rupees 30,000. I am ready to pay 15,000 per month from my pensionary benefit.
Said told that to the bank.
To the bank by a letter, my lord. That is appearing at page 51. My lord, please that letter.
51 years.
If my lord sees para 4 onwards, my lord.
She has three school-going children, all of them.
School-going children. The impute notice has within 2 months. Thereafter, she writes, my lord, in page 50.
Yes, I've read.
Yes. So, my lord, now, my lord, we say that she never said that I will not. Now, my lord, she don't have any source of income. She get a 30,000 rupees, out of which she is ready to pay 15,000 per month. Now, my lord, the bank reply at page 53. Second paragraph. But my lord, he knows, my lord, the authorities are bound by the legal procedure. They say, while the bank truly insisted that your personal loans and so and so you're facing, we are compelled to add. So, my lord, what I have on now, I had a talk with her. She received some amount, my lord, and she is ready to pay even 6 lakhs, some amount she is having. She said that amount at one go I will pay, and I will pay 15,000 per month. Once if she gets some job, my lord, definitely she will enhance. My lord, otherwise, my lord, this lady will be difficult because she has 3 school-going children. Where she will go?
You are ready to pay how much?
I received 30,000, my lord.
At one go, how much?
6 lakh rupees I will pay, my lord. I received some 7 lakh rupees.
Within what time you?
That I will pay within this week or within a week, my lord. I will pay 6 lakh because she told me on the other day she's having 6 to 7 lakh rupees. That she is ready to pay. And my lord, it is not that her husband during his lifetime if
Regularly paid.
Paid para 10, my lord. My lord, may kindly see. These are the loan details.
No, a sale notice has been put up already. This is a sale notice or what?
No, lastly, my lord. Now, sale notice was put only on 7th of April, my lord.
Sale notice has been put up.
My lord, can you see para 6, my lord? Page 6, para 10. My lord, husband has obtained first loan, firstly 39 lakh. He has paid 37 lakh 26,000. He was regularly paying, but due to this.
Normally courts.
No, my lord, I said, my lord, I don't have legal right, my lord.
Of the bank.
Yes.
You're supposed to appear for the lady on behalf of the Legal Services Authority. We're appearing for the bank. You don't have any locus standi to appear for them. We won't hear you. Use the microphone, please. Yes.
As per section 17 of the Circuit Act, he has no right to file this application.
He has no right to file this application, not as per section 17, but as per section 34, read with section 7 and section 30. Let us break the law for a.
Already.
Let us go against the law. Have it set aside by the division bench. This division bench, this before next Saturday, you cannot do that. So let us pass an illegal order.
Yeah. At least the time will be given. I agree. No.
Yes. We'll give you 6 weeks, 8 weeks, whatever you want. But it will be stayed for that period. It cannot be Shylocks. Cannot be Shylocks. Let us pass an illegal order. Yes. The present.
The position already taken by the bank also on 4th April. After
You are still in possession, Mr. That was notional possession, symbolic.
symbolic possession.
Sale has been effected.
No.
Sale has been effected.
There has been not yet.
Then how could you take possession?
No, after issuing notice, such a notice, thereafter the.
13.4. When do you take possession? Where is the paper of possession?
The 54 is the symbolic.
This is not a sale notice.
No, my lord, the possession was given.
Possession note 13.4. This is 13.4. This litigation is the story of an unfortunate lady whose husband, the sole bread earner of the family, met his demise on, what is the date, Mr.
Yes, my lord. This is on 24th of May 2025.
May 24, 2025. So the next para, the writ petitioner has 3 school-going children and has almost no source of income. Stop. After running from pillar to post, the writ petitioner could somehow obtain orders from courts and have the pensionary benefits, which she is entitled to on demise of her husband, disbursed in her favor. Push up next para. However, the petitioner discovered that her husband had left a housing loan, with which the dwelling house of the petitioner and her 3 school-going children was constructed. Push up next para. The petitioner, upon coming to know of the same, approached the bank with an offer to pay whatever amount she could, going to the extent of 50% of the monthly pension which she was receiving. Push up next para. However, the bank expressed its empty empathy, but proceeded with measures under section 13 within bracket 2 of the Surface Act 2002, and thereafter took symbolic possession of the same by publication of a possession notice under section 13 within bracket 4 of the said Act. Push up next para. Learned counsel for the petitioner contends, as per instruction, that the petitioner, having somehow accumulated money, is willing to show her bona fides by paying an amount of rupees 6 lakh within a week from date. Full stop. The petitioner further seeks some installments in order to clear the loan taken by her husband. Full stop. Next para, learned counsel appearing for the bank controverts the submissions of the petitioner and submits that the present proceeding is barred under the provisions of the SURFACE Act. Full stop. Next para, moreover, comma, it is submitted that the bank has already taken possession of the property of the petitioner under section 13 within bracket 4 of the SURFACE Act. Full stop. Next para, you are appearing for which respondents? Not for the bank. Must be for all three. Branch manager, submit on behalf of the bank na bole authorize. Next para. Upon query of court, comma, learned counsel for the opposite respondent number 2, comma, who is the authorized officer of the concerned bank, comma, asserts that he is appearing only for respondent number 2. Full stop. Such conduct of the bank is surprising, comma, in having engaged counsel to appear for the authorized officer, that is the chief manager of the concerned bank, but having not entered appearance itself through counsel. Full stop. Evidently, comma, it is a ploy to avoid any adverse orders being passed against the bank. Full stop. If the authorized officer could be represented by counsel, comma, the court finds no reason as to why the branch manager of the State Bank of India, comma, main branch, and or the branch manager, comma, State Bank of India, comma, evening branch, comma, Sri Vijayapuram, could not represent themselves through counsel in the matter. Full stop. Next para, be that as it may, comma, the court is fully aware of the restriction under section 34 of the SURFACE Act 2002, which debars civil suits in matters which is within the power of the authorities stipulated under the said act to entertain any civil suit. Full stop. Since measures have already been taken under section 13 of the SURFACE Act, comma, an alternative remedy is available to the petitioner under section 17 of the said act to approach the concerned debts recovery tribunal. So next para. However, comma, two aspects of the matter have to be factored in. So first, comma, the bar under section 34 pertains only to civil courts and not to judicial review of constitutional courts under Article 226/227 and or under Article 32 of the Constitution of India. Full stop. Secondly, comma, the power of judicial review, comma, which forms a component of the basic structure of the Constitution of India, comma, cannot be curtailed by a servient legislation of the Parliament, comma, which the SURFACE Act is. Full stop. Next para. It is also well settled that the constitutional courts, comma, in exercise of the writ jurisdiction, comma, have ample power to interfere if gross injustice is done or the legal or constitutional rights of a person are violated. Full stop. Next para. In the present case, comma, although the bank abided by the letter of the law, comma, it completely missed out the forest for the trees by failing to appreciate the spirit of the law. Full stop. The petitioner, comma, in her position, comma, showed utmost bona fides in her letter dated March 30, 2026, annexed at page 51 of the writ petition, by offering to pay to the extent of 50% of her monthly pensionary income. Full stop. Despite the same, the respondent bank played Shylock and went after their pound of flesh by going ahead with the measures taken under section 13 within bracket 2 and section 13 within bracket 4 of the SARFAESI Act. Full stop. Next para. The court is taken aback by such approach of a nationalized bank, which the function of which is not restricted to recovery of loans, but also to provide aid and succor, SUCCOUR, to the marginalized sections of the society. Full stop. Next para. In the present case, sufficient bona fides have been shown by the petitioner by approaching the bank to offer her best give her best offer, but the same was turned down by the bank without giving any reason whatsoever or responding to the same. Full stop. Next para. Even otherwise, the so-called position taken under section 13 within bracket 4 of the SARFAESI Act is only a symbolic position, and the physical position of the petitioner is still with her. Full stop. Next para. In view of the above exceptional circumstances, this court invokes its powers of judicial review under Article 226 and directs and entertains the present revisional application to be heard on merits. Full stop. Next para. There shall be stay of. Now, the respondents shall remain restrained by an order of injunction from taking any further steps pursuant to the demand notice under section 13 within bracket 2 and possession notice under section 13 within bracket 4 of the SARFAESI Act 2002 issued by the respondent authorities, as well as from selling, transferring, alienating, and or creating any third-party interest in respect of the secured asset, which is incidentally the only dwelling house of the petitioner and her 3 school-going children, till disposal of the revisional application. Full stop. Next para. The respondents shall further remain restrained by an order of injunction from disturbing the possession and enjoyment of the petitioner and her family in respect of the secured asset in any manner whatsoever, also till the disposal of the writ petition. Full stop. Next para. However, such order shall be conditional to the petitioner paying an amount of rupees 6 lakh, as offered by her, within May 15, 2026 to the respondent number 1. Full stop. If such payment is made, the respondent number 1 shall accept the same without prejudice to the rights and contentions of either of the parties, in the writ petition and or in any other proceedings. Full stop. Next para. The petitioner shall serve copies of the writ petition afresh on the respondent number 1 as well as respondent number 3, and file an affidavit of service to that effect on the returnable date. Full stop. They can serve copies of the writ petition along with the server copy of this one, and file an affidavit on the returnable date. Full stop. Service on the respondent number 2 is dispensed with in view of appearance of the said respondent through counsel. Full stop. Next para. The parties as well as all concerned shall act on the server copy of this order for the purpose of compliance without insisting upon prior production of any certified copy.
Yes, sir. Affidavit, my lord, if they want to file.
What if?
My lord, one more thing, my lord, I think that I have filed an affidavit of service, my lord, in terms of the order.
Prothom line affidavit of service filed today, and I have also stated afresh.
Yes.
Copies
That
are-
I will do, my lord.
Great. Good.
Great.
Returnable date. The matter shall next be listed in the circuit of before the appropriate bench in the circuit after the next circuit for hearing.
Obliged.
Yes. Next.
Then number 14. WPA 166.
Yes. Yes. Yes.
Purchasing of 200 square meter along with the other code.
Square feet. 200.
200 square meter
Oh, land. Sorry.
land.
Yes.
Thereafter, here there was a notice
Yes.
acquisition. He has filed a representation before the authority. If the land is acquired, the appropriate amount has to be compensation.
Under the Land Acquisition Act, 1894 Act.
After that, he has paid if the acquisition is done in that,
Compensation.
so compensation has to be. One finding, it was not done, it was, the representation was given in the year 2020. Thereafter, nothing was done. Then the legal notice was given on 2021, in the year 2020. Thereafter, the collective land acquisition has given a letter by saying that your land has not acquired. Because it is a chunk of land, big chunk of land. I have
Other
purchased
portions.
200 square meters of that.
You have purchased a demarcated portion.
No, my lord. No, my lord, I'm coming to that. I'm coming to that. Thereafter, my lord,
When did they give this letter to you saying that they have not acquired?
it's 18/9/2020.
Oh.
By saying that it has not affected. Thereafter, my lord, by way of RTA, I have taken out the award which was given. In that, my lord, out of the total 13%, others have taken the compensation, they were received with the compensation, their land has been affected. Only 3%, including the petitioner, their land was not affected for compensation. Land acquisition was not there. This was for the purpose of installation of glide path. The acquisition was done for the purpose of installation of glide path.
What path?
Glide path, GLID.
Is it?
For airport
acha, acha.
purpose.
Good.
Airport purpose. Thereafter, my lord, the petitioner has filed a representation for demarcation of it after getting the award, wherein the other persons are given with the compensation. So 3% left, the petitioner has given.
That has to be done before the Tehsildar.
My lord, the Tehsildar demarcation fees was paid. Thereafter, several notices were given, but the demarcation was not done. Thereafter, the petitioner has prepared a split petition before this honorable. This honorable court has passed an order.
Yes.
Wherein, this is from here, it's a page 56, starts from page 56, relevant page is 69. From para 8. On a perusal of the report, the court has failed to understand as to how a portion of the joint property could be acquired and compensation given to only a few of the co-tenants. It is settled law that in a joint property, each and every co-sharer has right in each and every inch of the said property. If the entire chunk of land is survey number 144 of the 2/P is undivided and only a portion of it has been acquired, then all of the co-sharers will have a right to a part of the compensation awarded to the land process. Only if the land is divided and demarcated among the co-sharers, then the authority can ascertain as to whose for the portion of the land has been acquired for which compensation is to be paid. In the instance case, the Tehsildar admits that the land is undivided and demarcated. At the same time, he submits that the petitioner is required to apply for subdivision. The petitioner has a formal deed of sale in his favor, and the area of the land purchased by the petitioner is mentioned there. The authority must have identified the portion of the land which has been acquired. The same implies that the balance portion of the land in the subject survey number, which has not been acquired, belongs to the petitioner and other two co-sharers who have also not been paid compensation. In view of the above, the Tehsildar is directed to conduct a spot inspection upon prior notice to all the necessary parties to ascertain and demarcate the land which has already been acquired. From there, the portion which has not been acquired can be identified. The unacquired portion is to be subdivided among 3 co-sharers in the share mentioned in their respective fields. The petitioner shall be communicated the details of his share after demarcation. This was the order passed by this honorable court. But thereafter, nothing was done. I have filed a complaint. In the content application, they have come with a compliance. In the compliance can be seen, my lord. And along with the compliance, they have filed some documents. Wherein, it's a page 68 is the report. But here report, I'm reading here.
Yes.
During the course of demarcation, the following facts were observed on the spot. An area measuring 0.0198 hectares of land proposed survey number so-and-so is under the occupation of some person. Again, second, 0.94 hectares is proposed is under this occupation of some person. And area 131 hectares proposed is some person. Third, if it is calculated, but here the total land of 144/2/P is, my lord, it's
Less than 200 square meters.
my lord, its total is total area is 0.2207 hectares. Out of that, acquired land, my lord, I'm coming to that, my lord. I'm coming, let me submit, my lord, first. Out of that, 0.1550 hectares of land has been acquired. Their report is there, it's a page 71, they have annexed. My lord, now the rest land is, the balance land is 657 square meter of land. 657 square meter of land. Now, my lord, out of 657, they are showing the 3 persons' name and they are acquired with the, they have constructed some house there in the occupation. That amounts, that free calculation will come around 423. Still, my lord, 234 is there. Where is that 234? That 234 square meter of land, my lord. I am entitled only for 200 square meter of land. And kindly be seen, my lord, in the demarcation report, page 70. On that particular day, my client was present. 70, my lord. My client was present. He has signed. What is it? It is written. I'm reading, my lord. In the down portion, it is written. Signed only to mark present. No boundary demarcation was done. No action to hand over land has been done. So, my lord, here, if we are calculating this 3, it comes around below 657. 657. It is not acquired by the department, by the authority.
As per their calculation, 6.6290 has been acquired.
No, my lord. There, kindly see
Page
the-
71, total area is 6290. This is the
No, my lord. The Sushila Mandal and 12 others. That is the second one.
Huh.
144/2.
oh, only the second item
Second
2 is your right.
Yes. 144/2/P 0.2207 total area. my lord. Out of that,
But the next one is also by 2/P. Item
This
3.
is not coming under my discipline. Records of rights are there. I have annexed P1.
So your name has been recorded in respect of a particular portion within that DAB.
144/2/P along with the Sushila.
But if
Mandal
there is
and
no
12
division, no demarcation, then how can you?
Here, there is no demarcation, nothing is there, but they have acquired the rest of the land, 9 persons land.
Really, I am also at a loss to understand how they could acquire without demarcation.
See the award bonds, my lord. It is mentioned, their own award. Can we be seen, my lord? It's a page 30. Relevant page is 36. And we be seen bonds, my lord. Relevant page is 36. It's kindly see, it's serial number 4, 144/2/P. If your lordship will see, it's in hilly land. First name is Sushila Mandal. No, last column is not within affected area. And next is Neeraj within affected area. And again it will come Durgavati Devi not within affected area. So affected area, not affected area, they have themselves, they have mentioned.
Your name is not there?
My name is there. Next page 37. It's second last. They have a day.
Yes.
Not within the affected area. Out of the 13 persons, 11 persons land has been affected area, they have given with the compensation as per the land acquisition. 3 persons left, my lord. Here, my lord, the other 2 persons are not claiming. I am claiming. So here, 200, if these 3 persons,
Even if the other 2 persons are not claiming, their land cannot be directed to be given to them.
claiming it, my lord, because either it will be a land or it has taken by the land acquisition
Yes.
for the purpose of life. Any one I should get, my lord.
Ah.
I had a land.
Either compensation or
Or the land. They are not showing me the land. And in the contempt, my lord, kindly receive the last order. Contempt order. There was a liberty to file a fresh because, my lord, this was the compliance they have filed before the contempt court, my lord. Now, para 3 starts, my lord. It's page 73 is the order.
Yes.
The spot inspection has been conducted. A report of spot inspection with specific findings as regards the share of the petitioner in the subject plot of land shall be formally communicated to the petitioner. This was not done. Never done. This order is there, but we have not received it. It will be open for the petitioner to challenge the finding of the tahsildar if the petitioner is aggrieved by this. But here the land has not shown to me, nor the compensation they have given.
After this, did you give a fresh representation after this contempt proceeding? No.
No, my lord.
Because what is your cause of action for this coming afresh? Because the contempt court, the court says
Liberty.
it will be open to petitioner to challenge the finding of the tahsildar if the petition is agreed by the same. So there is no finding because they have not yet communicated even to you.
But I've received along with the compliance I've given with the all these documents, my lord, along with this.
The learned single judge held para 3 that the spot inspection has been conducted. Report of spot inspection with specific finding as regard your share shall be formally communicated to you. Upon that communication, if you are agreed by that, you are entitled. So,
It was not communicated.
so let us ask the authority. You are appealing for the authorities. So let us ask them. Yes, what about this? First of all, you can't understand. I can't understand how an undivided portion can be acquired without. Then everybody has a right. Every portion should give compensation or the land. Same doubt was expressed. You had not filed a badly conducted on your behalf. Well, bring everything on record so that she can get a solution. Her client can get a solution at least. Learned counsel appearing, Stephen. Learned counsel appearing for the writ petitioner submits that the writ petitioner purchased 200 square meters of land out of a particular plot being plot number. This is 144 by P by 2.
142 by 2 by P.
That's 142 by 2 by P. Who's the next para? Upon the petitioner coming to know about the proposed acquisition of the said property along with adjacent other lands, the petitioner wrote to the respondent authorities seeking compensation if such acquisition takes place. Since there was no reply to such communication, given in the year 2020, a legal notice was served in the year 2021. Next para. Subsequently, only on September 18, 2023, the petitioner was intimated that the petitioner's land had not been acquired. The petitioner, upon seeking information under the Right to Information Act, came to know that an award had already been passed, which reflected that the land in the adjoining area of the petitioner's land had been acquired for a glide path, upon which 13 persons had been given compensation and 3 persons had been omitted, on the ground that the land of the latter persons was not acquired. Which of next para. Subsequently, the petitioner sought for a demarcation of his plot of land before the tahsildar. Since the tahsildar sat tight over the matter, the petitioner had to approach the writ court and obtain a direction to that effect. Subsequently, upon there being non-compliance of the court's order, a contempt petition was filed, in which an affidavit of compliance was filed by the alleged contemner, an official of the respondent authorities, from which it transpired that some portion of the concerned plot still remained unacquired. According to the petitioner, the unacquired land is more than 200 square meter. So accordingly, the petitioner claims that either the petitioner ought to be returned her land, or adequate compensation is to be paid to the petitioner. So next parallel counsel, apart from taking the court through the documents annexed to the writ petition, also places reliance on an order dated March 12, 2026, passed in WPCRC 1 of 2026, where where a coordinate bench, sitting in contempt jurisdiction, had recorded that spot inspection had been conducted, and a report of spot inspection with specific finding as regards the share of the petitioner in the subject plot of land shall be formally communicated to the petitioner. On such observation, it was the contempt proceeding. The contempt proceeding was dropped, with the further finding that it would be open for the petitioner to challenge the finding of the Tahsildar if the petitioner was aggrieved with the same. So next para, however, it is submitted that no report of spot inspection, let alone with any specific finding as regards the share of the petitioner in the subject plot, was ever communicated to the petitioner. So next para, thus, the petitioner has approached this court seeking remedy with regard to her 200 square meter plot of land. So next para, learned counsel appearing for the respondent authorities seeks an opportunity to file affidavit in opposition to bring on record the relevant facts and documents. So accordingly, the respondents are directed to file their affidavit in opposition within what period, is this? Within 4 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Within 1 week thereafter. Full stop. Liberty to the parties to mention the matter for enlistment before the next available circuit after the aforesaid time frame for filing of affidavits is over. Oh, I have identified with you. Sorry. Petition she will get short. Yes.
Item number 15, WPA 175 of 2026.
It's a simple direction. I have a specific plot of land.
Yes.
And I have submitted an application before the authority for supply of record entry and sketch map. The only
Supply of, sorry?
record entry and sketch map in respect of the land in question, and the license it is at page number 11. That license is there. I am paying the land revenue also. Page number 12 is the land revenue receipt, and the only difficulty is that by mistake, in my representation, I have mentioned the survey number as 204/12 instead of 204/7A. And in the license, it is clearly mentioned what is the actual survey number.
So your cause of action is that they have not given you this in front of this,
The record
the sketch map, and
yes.
Yes, different survey number.
so we'll direct you to treat this writ petition as a representation, and yes, the petitioner makes. Why did you move this application?
It was submitted.
No, it's a family matter. You should have let your. In these matters, you should not move anymore.
Yes.
There are more competent people in the.
Yes.
So yes.
No, I was instructed, but they said there is a problem in the representations.
Problem with the representation and the court. The prayer in the writ petition is innocuous. The petitioner has annexed documents to the writ petitions to indicate that the petitioner is the owner of the subject plot, in respect of which the petitioner made a representation to the Tahsildar, HON'BLE, Little Andaman, seeking record entry, seeking the relevant record entry and sketch map in respect of the subject land. However, learned counsel for the petitioner submits that there was an error in mentioning the survey number of the plot of land, instead of 204/17,
204 by instead of 204/7A.
7A. Yes. Instead of within quote unquote 204/7 capital A.
Capital.
7 capital A. comma, quote unquote, 204/12 was mentioned in the representation. Push up next parallel. Counsel for the respondent's authorities submits that in view of the said error in the representation, comma, the said documents could not be handed over. Push up, be that as it may, comma, since both parties are appearing before the court, comma, the respondent authorities are directed to treat the present writ petition as the representation of the petitioner and furnish the survey entry and the sketch map as per the requirement of the petitioner to the petitioner, comma, at the earliest, preferably within 4 weeks, from date. Push-up, WPA 175 of 2026 is disposed of in the light of the above observations without any orders to cause. The parties shall act on the server copy of this order without insisting upon prior production of a certificate.
Obliged.
Affidavit of service you have filed.
Yes, Your Worship.
Actually, oh, it's filed in the department here.
Department.
Item 68, WPA 178 of 2026.
Your Worship, the investigator.
Yes, Kitty will give up to respond to one instance.
Here there is one problem, Your Worship. The private respondent, we have sent it through post, but I have come to know that the private respondent is not in station. But the counsel for the private respondent in a similar matter, Your Worship, where civil suit is pending, that I can serve to him, Your Worship.
He will say that I don't hold power to appear. If it was in connection with the civil suit, you could have done
Yes,
that.
it is.
This is a writ petition.
Your Worship, I will satisfy this.
No. No, if it was directly arising out of that suit, then constructively we might say that he has power, but
Exactly the same suit property, same person,
maybe,
and violation of the order.
but the power is given for appearance in the suit, means now. How can we saddle this responsibility on that, on the advocate?
We have sent it, Your Worship. Your Worship, I kindly fix it day after tomorrow.
Let us do that.
I will try. Let there be no order. I will try to
Right.
get it, sir.
So later, I'm recording an order. Learned counsel for the petitioner submits that although copies have been sent to all the respondents, comma, insofar as respondent number, which respondent? Private.
3. Private respondent number.
Insofar as private respondent number 3 is concerned, comma, the service has not yet been completed. Full stop. Accordingly, comma, in order to await such service, let the matter stand adjourned till April 24, 2026.
WPA 184 of 2026.
Not written, nothing, not.
Item 80.
18 and 19. Yeah. Thursday, you are for the petitioner. On the prayer of learned counsel for the petitioner, comma, let the matter stand adjourned till April 23, 2026.
Item 20 CO 16 of 2026.
Yes.
But I'm very for the petitioner. I'm
Right.
for the private respondent.
Oh, yeah.
Petitioner under section 24 of CPC for transfer of the matrimonial suit from the court of the learned additional district judge at Mayabandar to the learned family judge at court.
What is your ground? You are designing here.
Yes. There is already a maintenance case that has been filed under 144 of BNSS before the learned family judge at court Blair. And after that particular maintenance case being filed, the husband has instituted a matrimonial suit for divorce at the court of additional district judge at Mayabandar. So I'm seeking transfer for that particular matrimonial suit.
What is your position? I mean, you have a child.
No child. Inconvenience in traveling. There is no house or no place of residence for the petitioner at that particular place. And as she has been removed from the matrimonial household, she does not have even proper source of income as well, because she's not working. And that is the reason by which she has also filed an application for maintenance. And in that particular application for maintenance under 144 of BNSS, the husband is appearing in this particular court, that is at court care, at the learned family judge at court. Furthermore, I have also mentioned in my application that if she happens to travel to that at Mayabandar, she cannot expect to return back to Port Blair in the same day. So for that reason, she cannot feel safe to reside there because she will have to then find an accommodation.
Yes, what do you say? You're already in a disadvantageous position in law.
has taken it from that eruption.
Yes, take the microphone a bit closer.
Recently,
Yes.
Pradesh High Court in February 2020 passed an order.
Which High Court? This High Court?
Madhya Pradesh.
Madhya Pradesh.
Taking into account the order passed by the Honorable Supreme Court also, that convenience of the wife will not be taken into account for transferring the matter. You also kindly appreciate on 6th of May, 6th of October, Your Lordship, the husband issued a notice, legal notice for divorce, Your Lordship,
It's October 25.
25. And on 14th of October.
What is a notice for divorce? You filed a suit for divorce.
Prior to filing of the suit for divorce, a notice was issued, Your Lordship. After receiving that notice, Your Lordship, on 14th of October 2025, the wife has filed the maintenance application before the court, Your Lordship. Now, Your Lordship, the entire cause of action and incident, Your Lordship, with regard to the matrimonial dispute and the witnesses and evidence, all is happened in the northern middle Andaman district, Your Lordship, within the purview jurisdiction of the Mayamada court, Your Lordship. Now, Your Lordship, only for the sake of the wife, Your Lordship, only for the sake of her, because after the dispute has been taken place, Your Lordship, the wife, whether yet she has decided willingly or I have given him her house, it is matter of trial, Lordship. But she has came back to the court there and residing with her brother house, Your Lordship, since 2025, as per the statement made in the maintenance case, Your Lordship. So, I humbly pray, Your Lordship, now you see there is a provision of video conferencing also. And there is not, it's not the case, Your Lordship, in each and every case, she has to appear before the honorable court, Your Lordship. But taking otherwise, Your Lordship, only on the sole ground of inconvenience, this transfer application cannot be taken into account, Your Lordship, because it's a hardship to the husband also, Your Lordship. The entire incident, the mother of the husband, who is a aged lady, Your Lordship, she has also come down to court where and other witnesses, the matrimonial house was seeing the incident, Your Lordship, and the stories, Your Lordship, and the complaint from the panchayat as well as police, Your Lordship, all things done in the northern middle Andaman district. So I humbly pray, Your Lordship, the matter may be and if Your Lordship, as per the Supreme Courts and the High Courts, Your Lordship, if in the hardest form, Your Lordship, I can afford the residence and that traveling allowances, Your Lordship, to the wife if she is coming to attend the court, Your Lordship. So may I please the judgment of the High Court?
I'm on the same point,
Judgment of this order. Exactly to the same point. Inconvenience of wife has to be considered.
So then you first cite your judgment so that you can answer that.
I'm just giving you judgments of this honorable court is one of the orders, not possible just yes, except distance, no further case of.
You say, Elango, you come prepared with this judgment, you'll take it up tomorrow. You exchange the copies of the judgments between yourselves today. Right? So whatever judgments both of you want to cite, you exchange between yourselves. You'll hear this matter tomorrow. I'm keeping it part not part I'll keep it at the top tomorrow. No. Top slot is blocked. And singly blocked. Second cover for it. So this will be the second or third top whatever. Although the record although the matter is taken up for hearing, in order to enable learned counsel to cite certain judgments and to exchange copies thereof between themselves, let the matter stand postponed till tomorrow when it will be listed fairly at the top of the list.
Right.
What sense?
Item 20 Sarah 23 of 26.
The Lordship, I have a place for the petitioner. I filed this application for washing under 528 of the PNS.
Other side. Come back tomorrow. Although the petitioner is represented, none appears.
Afraid that if we get the top of the list, the last 3 days I'm running for this.
Oh.
And the adjournment is being taken to be read.
This is a bail application.
No, Your Lordship, for quashing of the proceedings.
Not just. What is the nature of the proceeding?
That's actually, Your Lordship, this is purely civil in nature, and a criminal picture has been given to that particular action. That is,
No,
there has been
you-
an accident from which
Your quota for top matters today is over. So if I can't reach tomorrow, then tomorrow also. Despite the presence of the petitioner, comma, none appears for the respondent at the time of call. Let the matter stand adjourned for the.
Right.
Number 22, 3 of 26.
Not true. All right.
There is a talk of compromise going in between my client and the client.
Simply adjourn to the extent.
The second interim order needs to be extended.
Even Ms. Nagar appearing and there will be a compromise, I can't believe this. We will be deprived of good arguments from both sides.
Take time, compromise will be made. Let's take
So next circuit.
interim order may kindly make, interim order makes.
What is the interim order?
Lordship, the impute execution.
Execution.
Lordship, that needs to be.
So we'll extend it for say till the end of May.
In May, there is
No, sir.
ensuing mediation.
Should it extend it till the disposal? 10 June is the next circuit.
8 June it starts, let it be up to date.
No, 10 June will be too close. If by any chance it does not come, learned counsel for the parties submit that there is a chance of settlement between the parties.
Let that not be recorded, otherwise it will be very difficult. to
Learned
make
counsel
a-
for the petitioner submits that there is a chance of settlement between the parties. Full stop. Next para. In order to explore such possibility, comma, let the matter stand adjourned till the next circuit. Full stop. The interim order granted earlier is extended till May 15, 2026 or until further order, whichever is earlier. Oh, June 15, June 15. Sorry, not May, June 15. June 15, not.
Item 23, WPA 39 of 26.
Not really. Your adjournment is refused. Move the matter.
We have filing a report.
Not today.
Item 24, WPA 146 of 126.
So, this is a matter which I have mentioned on this side. Second, there's an interim order granted by the principal court. There was an extreme emergency.
So take up the matter.
This has to be because affidavit needs to be filed. I can argue to take time, but there are certain points which I have raised in the.
So I'll keep it in the next second then.
Till such time the interim order needs to be extended.
What do you say?
The specific direction was passed by this honorable court upon the respondent
Yes,
authorities,
sir.
because on the sole ground the additional stay was granted.
Because since the demarcation was report was not handed over to the recreational court, but the demarcation report was shown during the time of hearing. And the counsel for the recreational was present at the time of hearing, and the demarcation report was shown to it. And all those things, the proceedings and all, I have to bring before this honorable court, so I'm praying for filing my position. Because I have the proceedings below, where it is very clear that the demarcation report, everything was shown to the petitioner's lawyer, advocate was present, and the signature is also there. On
You are for the
that-
private respondent.
And for the private.
You are for the authorities.
Said order is available or
Suit is pending.
What has been challenged here?
But what has happened?
order passed by the Tehsildar, revenue authority, it's an appealable order.
It's fifth time before this court. Fourth time, because the land of the petitioner and the land of the private respondents are adjacent in its contiguous properties. But Tahsildar exercise the power under regulation 161 of 1966 regulation, which is a summary nature of proceeding. The order which the Tahsildar passed thrice was set aside on one or other ground by this court.
Anyway, if they want to use affidavits to direct affidavits, we'll extend the interim order for a limited period till 15 June. Learned counsel appearing for the respondent numbers 1 to 4 seeks an extension of time to file affidavit in opposition. Now, seeks some time to file affidavit in opposition to bring on record the necessary materials as per previous direction of the court dated April 2, 2026. Sir. Learned counsel for the petitioner seeks an extension of the interim order granted earlier. Learned counsel for the private respondent points out that the interim order was granted for a limited period only to enable the respondent authorities to produce materials in support of the claim that the demarcation was made in the presence of the petitioner.
It's not.
And the report was also supplied to the learned advocate for the petitioner. Next para, be that as it may, comma, the respondents, if you want to file, you also file your. The respondent shall file their affidavits in opposition within a fortnight. Within a fortnight from date, replies, if any, thereto shall be filed by the petitioner within a week thereafter. Let the matter be listed in the next circuit. The interim order granted earlier stands extended till June 15, 2026 or until further order, whichever is earlier. Since learned counsel for the private respondent seeks to raise an objection as to maintainability of the present writ petition, the question of maintainability as well as all other issues are kept open for being argued at the final hearing of the report. Thank you.
Other 25,
Yes.
Peculiar situation in which I've come up before this court. This case was started in 2008.
What is the other side, Mr. Kabir? Mr. Conrad, as usual, is very busy. He's always busy. When he's arguing about it, he's also very busy.
This is actually at the motion stage, so.
By me, it's started by Mr. Karnataka that he has got some urgent work, so he has left.
He'll have to file an affidavit on what is the nature of the urgency of the work.
Then domestic work.
No. Don't take you seriously on these things.
May I just save that time that I'll waste tomorrow by just introducing them?
We'll be wasting further time because I'll be signing orders and I'll have to be there till night, and they stayed here the whole night. Literally.
I'm aware.
Oh, yes. You should. Although the petitioner is represented at order record, although the petitioner is represented by counsel, although the petitioner is represented, although learned counsel for learned senior counsel for the petitioner submits that the matter is required to be heard, an adjournment is sought on behalf of learned public prosecutor. The next para, accordingly, let the matter stand adjourned for the day. However, it is made clear that no further adjournment will be granted in the matter.
The matter is clear at the top.
Top slot is. Oh, this has already been directed.
This is the one.
Then no order will be passed.
Then
I'm not passing it. Or then Mr. Karmakar must have anticipated that this will be taken up to vote.
I'll come back.
So then I'm not passing any order. Come back.
Good.
Yes.
I will know 26, WP 96 or 26.
Not
Item 27, WP 110 or 26.
same.
Item 20, WP 160 or 26. I think so.
Yes. You're appealing for the petition.
Not pretty.
Not true.
Item 29, WP 170.
It's just not good. Tomorrow.
Just not today. Just for the stress. Yes.
Item 30.
You have given a copy to the other side.
Admission was brought before the court number 1.
There was no caveat at the time of admission. It was
Nothing.
dismissed at the time of admission.
Admission was done.
Oh, what?
It was sent, single final hearing. Before the notice of appeal to be served, if the appeal was called on, I was on a medical treatment
Oh.
Chennai.
No.
That's the reason why I got requested on the day when the appeal was called on for hearing. I've annexed the medical documents also.
Your own medical document.
Yes.
Need not have
Council
councils.
got issues since from the last.
Councils.
I mean, explain them, not to fix the point that the others may not take some.
From a perusal of the. What is the application number? From a perusal of the averments made in the application and the materials annexed thereto, it is evident that sufficient cause for the absence of the petitioner on the relevant date has been made out. This has been filed within time, within 30 days. What's up next para? since, comma, on the date of dismissal of the appeal for default, comma, none had appeared for either of the parties, comma, including the respondent, comma, by invoking the provisions of Order 9, Rule 4 of the Code of Civil Procedure, comma, read with Section 107 thereof, comma, the application is taken up for hearing expertly. Full stop. As sufficient explanation had been furnished for the absence of the appellant on the relevant date, comma, can 1 of 2026 is allowed, comma, thereby recalling the order dated February 25, 2026, whereby ACT 13 of 2024 was dismissed for default and restoring the said appeal to its original file and number. Full stop. Let the appeal be listed for hearing in the next circuit. In the next circuit. Dispose of bullying? Hello, Pura.
Item 31, appropriate Declaration of 2024.
That's the response.
Even of the same round, Ashwati, this petition was also this.
Now the thought of the application to the admitting. Heard learned, Miss Das, we are allowing. We have heard you. Heard learned counsel for the parties, full stop. It transpires from the application and the annexures thereto that sufficient explanation for the absence of the petitioner on the relevant date has been made out. Full stop. Next para, accordingly, can 1 of 2026 is allowed, thereby recalling the order dated February 26, 2026 and restoring WPA 111 of 2024 to its original file and number. Full stop. The writ petition be listed. It was at the motion stage. Listed for 10 next second. Listed for hearing in the next second.
Item 32.
I appeal for the petition again. Karnataka is not there, but let it be given some priority.
No, private.
And my client is a cancer patient whose one of his kidney has been removed. And he's not an Indian, he's a citizen of UK. So.
This is item 32.
Yes,
What is the matter?
he has already been granted bail. He has been shifted from GBPAN from the jail to the hospital at mainland, where he was detected there was a cancer and his one of his kidney has been amputated and it has been removed. After that, there was a review checkup which was advised, but here we don't have a specialist oncologist. So he will have to go to either to mainland or to his parent country for getting review.
You want a relaxation of the bail condition for?
Yes, and why? Because my passport are with the authorities, so I cannot travel.
This will appear. There are already 2 or 3 matters fixed at the top after this. Yes. It none appears for the state at the time of fall, although the petitioner is represented through counsel. In view of the urgency pleaded by the petitioner, comma, let the matter be listed tomorrow fairly at the top of the list. The top rate 1 to 3 1 to 3 likhon.
Item 33, there are 6 of 125.
Not good.
Item 34, CRM 9 of 125, Withdrawal 2 of 125.
I appear for the petition, but a very innocuous prayer I have been prevented from going to my house, to my village by way of a bail order, which was granted long before in the month of December 2025. I'm residing in the rented premises at Dignipur till this day. So only I may be allowed to go to my house where my parents said I have been working there.
POCSO Act. The victim might be residing there only.
Same way, but at a quite long distance. I will not go. I will have to go to my house. I will have to work. I will have. Then only I can take care of my.
Not today, let Mr. Karnataka.
Maybe this one let Mr. Karnataka. Yes.
It can be transitive. I have to go to my house.
No, but you are. Let us see.
I live at home.
Let us see. We'll have to hear Mr. Karnataka. Without hearing, you should not know.
Fine.
Item
This is more serious, not like the previous.
Item 35, basically 14 of 125, with 10 of 125.
I am appearing for this.
Both sides are not appearing, I'm making note.
See, WPA 347 of 25 with
Of the restoration application, sit on that.
And to this.
What was the other item?
The item is lordship 31 and
No, where Miss Das was appearing?
31. 31.
31.
Okay.
And this is 36. Same order as the date. Oh no, the date is the same. Must be same, the same judge. Same order as 31. Only repetition number will be changed.
Okay.
Right. Same order, exactly same order. Next circuit for here. Thanks.
Item 37.
I'm a very regarding to the modification of my grievance.
No, but the state has to go. Let it appear tomorrow, let it. They are not appearing. Not today.
Item 38, CPL 29 of 22 with item 39 64 of 22.
Whose order is this?
Is justice maximum.
But then the court has to do. So not today then. Yes.
Item 40, CPL 30 of 24 with item number 41 W special 98 of 23.
Not today.
Item 42, CPL 68 of 95.
Justice.
Same.
Item 43, CPL 20 of 126.
Lord, I am appealing this order was passed by my Lord Justice Rai Chakrabarti.
Since the matter arises, since the contempt application arises out of an order passed by Rai Chattopadhyay J, comma, let the matter be placed before the said bench, whose of the registry shall take steps accordingly at the earliest.
Item 44, CPL 52 of 126.
Not today.
Item 45, CPL 23 of 126.
Same.
Item 46, CPL 24 of 126.
In this matter, appearing on behalf of the applicant.
Whose order is this?
Justice Aniruddha.
Oh, same order as the previous one. Has to be placed before the concerned judge. Only Aniruddha Rai Ji are registered to take steps. Yes.
Item 47, CPL 25 of 126.
Whose order?
Justice Rajamar.
Same. Justice Raja Basu Chaudhary. Go before that. 45 whose order? And 45, the 45 also কেউ ছিল না তো কলেজ ও আচ্ছা ঠিক আছে 45 also same দেবাংশু বসাক জি 44 whose order ma'am Sampa Sarkar same 44 so we are going backwards now exactly backwards serially backwards 45 44 yes 43 42 should we call no the very well yes ভুলিয়ে গেছে তোমার কোনটা লাস্টে কার অর্ডার দেখো তো আমি দেখি Sampa Sarkar same order just as Sampa Sarkar none appears for the party anybody appearing লিখে দিন none appears for the parties then whatever I pass Mr. Kumar you are appearing Rakesh Kumar after committing the contempt you have been removed
I was appearing to the
that's why I say so no if he does not have instruction he cannot no I'm not passing any order none appears same order just Sampa Sarkar ji এবার থেকে কন্টেম্পট যদি কল করতে দেখে নিতে হবে তাহলে আর ফালতু ফেলে রেখে না কল করে যখন আসার দরকার তখন এখন তো 4:30 বাজে এখন এই কাগজগুলো না ফেলে দেবে হ্যাঁ